Good afternoon, everyone. I hope everybody is doing well. Today is day 2 of the Douglas and Runger Estate Planning Mini Boot Camp. I am your presenter. My name is Kurt Runger. I'm an attorney in Memphis, Tennessee at Douglas and Runger, and a large part of our practice involves helping our clients through estate planning matters and probate estates. So yesterday we focused on part 1 of our estate planning mini boot camp, and we talked about the most important document in most estate planning packages, which is a last will and testament. Today we are going to talk about 2 other critical estate planning documents that most of you have heard of and are aware of, but some people might not know all the ins and outs about. And those are called powers of attorney. And so many of you probably have already executed a power of attorney. If you haven't, some of your parents probably have executed powers of attorney. But essentially, a power of attorney is a legal document that an individual can execute whereby they nominate another individual, and it's typically a family member or a close friend, to make decisions for them in the event that they are unable to make decisions for themselves by reason of being incapacitated or physical or mental infirmity. Okay, so these things are legal documents, and essentially what they're useful for is making your family members' lives easier. So if you're ever in a situation where you're getting of advanced age and you have memory loss or Alzheimer's or dementia, and you have a hard time communicating to your healthcare providers about what you would like to see done with your healthcare, and you've executed a power of attorney and you've nominated a family member, that makes it much easier on your family member because they're allowed to talk to your healthcare providers and other medical professionals about the type of treatment that you receive. There's also a durable power of attorney for business transaction. It's essentially the same thing. You're nominating another individual to make decisions for you and to transact business on your behalf in the event that you're unable to do so yourself. So I just wanted to kind of first run through some of the general considerations about both different types of powers of attorney, and then we can kind of go through and break down some of the things that apply for each of them. So some of the basic things is, first of all, when an individual executes a power of attorney, they have to actually have the capacity to do so in the first place. So we field a lot of calls from people all the times who they call us and they say, hey, I need to get a power of attorney done for my mother. And we start asking them questions about the mother's situation, and they say, oh, she's got dementia, she's got Alzheimer's, and she can't really communicate, or maybe my mother was in a coma, or my adult child is in a coma and they're unconscious and they can't communicate, so we need to get a power of attorney. So that's not exactly how it works. I mean, the decision to execute a power of attorney comes from the person who's actually signing it, and they have to have capacity to do it. So what that basically means is they have to understand what it is that they're signing at the time that they sign it, and they have to understand the legal ramifications of it. So if they already have full-blown Alzheimer's and they don't know what year it is and they don't know where they are, they're not going to have the requisite legal capacity necessary to even execute a power of attorney. So at that point, it's too late. And that's where the estate planning aspect of it really comes into play, because no one likes to think about these situations where their loved ones are going to be in a position to need this. No one certainly wants to think about it from their own perspective, but having these things created and having them in place can be very, very wise, and it can make your family members' lives a lot easier. Now, kind of what we touched on yesterday about, are these documents recorded anywhere? Is there some sort of a universal database where these powers of attorneys are recorded? And the answer to that question, like it was yesterday with the last will and testament, is no. That being said, there are certain situations where individuals do decide to record the power of attorneys in the registrar's office of the county in which they're locating. And the reason that people do that is basically so that usually you see it actually happen if you've got family members who are, or multiple parties who are kind of fighting for control over somebody's decision making or control of their finances, really. And these things are recorded sometimes by family members in the registrar's office to serve to kind of put the world on notice of the fact that, I am the attorney in fact for the person who executed the power of attorney. Backing up a little bit, so I should have actually talked about this first. So the power of attorney is actually the name of the legal document, and some people say, yeah, I'm power of attorney over my mother, and that's not technically incorrect, but you're actually, if you're nominated in a power of attorney by somebody, you're actually their attorney in fact. Okay, so that's the terminology. If you're taking action on behalf of somebody else who's nominated you in a power of attorney, you are their attorney in fact, or their agent. And so that is some terminology that you would need to know. Another thing too, you do need the original powers of attorney. So copies aren't really good. So when people come to our office and they execute powers of attorney, whether it's for healthcare or whether it's for finances, like they do with the last will and testaments, they leave with the original powers of attorney and take those with them, and they keep them in a safe place too, because their attorney in fact is going to need the originals when they're dealing with whether it's financial people or medical personnel. You can always revoke a power of attorney. So let's say that you actually name one of your children as your attorney in fact under a power of attorney for healthcare or a durable power of attorney for business, and you have a falling out with them. You can revoke that power of attorney by destroying it or by executing a new power of attorney. So the execution of a new power of attorney will effectively revoke an old power of attorney. These things, you got to be very careful. You got to be very careful when you try to decide who is going to be your attorney in fact. The other main consideration too is when we draw these up is a lot of these medical professionals and bankers too, they're very finicky about the actual names that are shown on the power of attorney. So when we're preparing these documents for people, we make sure that we actually have the full legal name of the person who's executing it as set forth on a Tennessee driver's license or a state issued ID card, as well as the address. And we also make sure that we have the full legal name of the attorney in fact that's going to be named in the power of attorney. Another question that people ask a lot of times regarding both types is, can I have co-attorney in facts in a power of attorney? And the answer to that is yes. You are allowed to name two people as your attorney in fact, whether it's for healthcare or whether it's for business. We typically don't recommend doing that because of the fact that the whole purpose for having these things in place is for a convenience factor for your family. And oftentimes, if you have named two people as co-attorneys in fact, then guess what? When they try to go to present it, the bank's going to want both people present, or the bank's going to want two signatures. The medical providers are going to want to know, hey, where's your co? So typically in situations like that, what we do is if an individual comes to us and says, hey, I'd like to name both of my children, we have them name a primary, and then we have them name like an alternate. And so we've found in our experience, at least in our market, that works pretty well, and that gives a little bit of flexibility to it as well. Now let's talk about what you can do as an attorney in fact under a durable power of attorney for healthcare. So this is a big deal because you're essentially stepping into your loved one's shoes, and you're able to do almost everything that they could do for themselves. So there's a great deal of authority that you have. And all of these actual powers that attorneys in fact have are set forth in our Tennessee statutes. But just to kind of run down a few, if you're named as an attorney in fact for somebody under a power of attorney for healthcare, you absolutely have the right to consent to, refuse, or withdraw consent to any types of medical care and procedures on behalf of your loved one. You also, and this is a big one, you also obtain access to their medical records and information. So HIPAA laws are in place. Many of you may have heard of HIPAA laws. It's the federal privacy laws that are in place that protect your medical information and stuff like that. If you're named as an attorney in fact under a power of attorney for healthcare, you are actually going to have access to those medical records, the same rights as the person who's appointed you would have. You can authorize admission or discharge into any types of facilities or hospitals or assisted living centers. You can contract any types of medical services. You can hire and fire medical staff, and you can basically sign documents on behalf of people. You can make advanced arrangements for funeral and burial. Another big thing about both of these for the power of attorney of healthcare and the durable power of attorney for businesses, when you execute one of these, okay, you are essentially you're essentially ratifying any type of act that your attorney in fact would take on your behalf. So what that means is you cannot name your child or your spouse as attorney in fact under a durable healthcare power of attorney and then turn around and sue the facility who honored you executing the power of attorney. So in other words, if you're in Memphis and you like being treated at Baptist Hospital and you've nominated somebody as a power of attorney, and your attorney in fact actually doesn't take you to Baptist, they take you to St. Francis Bartlett, and then you come out of whatever the condition you're in, and you're mad that you went to St. Francis and that they did something you didn't want to do. You cannot sue St. Francis for accepting and honoring the power of attorney that you executed, directing them and directing other people to allow your attorney in fact to make decisions for you. So that's a big deal, and that goes along as well as the on the durable power of attorney for business. A couple other highlights on these things. So when we prepare these documents, they are intended to be valid in any jurisdiction in which they're presented. Now, that is not a guarantee that if you do one in Tennessee and you move to Alaska, that Alaska is going to honor your agreement. We can't do that. We can't make those guarantees because we have no idea what they would do. However, they are intended to be valid in other jurisdictions. And the counterpart to the durable power of attorney for healthcare is the one for business. And same kind of high points there, except this is where things can go really, really awry. You have to be very, very, very careful and you have to trust, really trust implicitly the individual that you would appoint over your finances, because that appointment creates a fiduciary relationship. And the nightmare scenario, the absolute nightmare scenario, and I've been doing this for 17 years, and I can tell you I see this all the time, is you have a family member who appoints another family member, a child or something like that, as an attorney in fact under a durable power of attorney for finances, and that agent, that attorney in fact, they have the capability to self-deal. So in other words, you nominate somebody else to be your attorney in fact, they can take that power of attorney and they can go to the bank and they literally could wipe out your bank accounts. I mean, they could wipe you out and take all your money. And where this becomes problematic is when you've got somebody with money and somebody of advanced age, and you've got people who are kind of fighting for control, and it's really despicable, but they're only concerned about getting their inheritance on the front end or doing things wrong, and so they'll misuse the power of attorney to convert an individual's money and assets to their own use. So that is a big, big, big deal. You've got to be very, very careful about who you trust with that, because these things, the medical one and the durable for business, they're really only supposed to be used when an individual is not able to make decisions for themselves. Okay, when they're not able to do them, they're really kind of like as a last resort. And if you sign one and you go to a lawyer like me and I prepare one for healthcare for you and I prepare one for finances for you, I will tell you all of this, and I'll spend much more time going over all the different things that are included in the statutes. But I will tell you, look, hold on to these originals, keep them in a safe place, and let your attorney, in fact, know where they are. But don't get don't don't let them use them unless they have to have them. It's kind of a last resort, right? I mean, you want to be able to handle your own affairs, and these are really just for convenience and to help people out when you're not able to do so. So that is essentially the Cliff's Notes version of powers of attorney. Now, I would be remiss. This is about estate planning, obviously, and this is the estate planning boot camp, but we do prepare powers of attorneys, limited powers of attorneys for other purposes, such as if somebody who runs a business wants to execute a limited power of attorney for another individual to take limited action on behalf of the company or on behalf of them. I've done that before quite a bit in the past. You also, in Tennessee, we see this from time to time where you have parents who can actually sign a power of attorney to give another family member permission to deal with school systems and try to enroll their child in school systems. So those actual powers of attorneys are out there, and those exist well. But for estate planning purposes, we're really talking about the durable power of attorney for healthcare and the durable power of attorney for financial transactions. So if there aren't any questions, that is basically a wrap for day 2 of the Douglas and Runger estate planning mini boot camp. So yesterday we talked about the last will and testament. Today we talked about the durable power of attorney for healthcare and the power of attorney for financial transactions. Tomorrow we will hit the living wills, and like I said at the beginning of all this, these 4 documents, the last will and testament, the power of attorney for healthcare, the power of attorney for finances, and the living will, these are the cornerstone documents that really constitute the basic estate plan package. And these are documents that you may not think you need them right now, but you probably do, and it's a good thing to have. So if anybody has any questions about this little presentation or questions on powers of attorney or rights or obligations or anything like that related to them, please make a comment in the comment box. You can always send me a DM on Facebook or email me at Kurt, C-U-R-T, at douglasrunger.com, and I'm happy to answer any of those questions. And like I said yesterday, I am going to prepare sort of a follow-up PowerPoint presentation on this thing on Zoom where I have the actual slides and I go over everything in further detail. And I'm going to post that in this Douglas and Runger Facebook page for everybody to go back and look at so that you actually have something to go by. I said this yesterday. I tried to go through the screen share in Facebook. I just don't like it. I don't think it looks very good. The screen kind of gets screwed up, and I'm much more comfortable, and I think Zoom is a much better platform. So I will do that later this week. All right, everybody, have a great rest of your day, and I will see you tomorrow at 12 noon, and we will talk about living wills. How exciting.